Hello and welcome back to Justice is a Process. My name is Steve, and we are here to discuss justice and what's happened this week in the justice system over the last, really, I guess, last week and a day. We had a holiday in between, but we've had a lot happen. So we're gonna talk about a couple of things that occurred that went down last week, and then we're gonna get into the big trial that's going on now today is the Young Thug RICO trial after what I would say is a record long jury selection of 10 months. The trial started in January with jury selection. November 10th, the jury selection ended. There's been pretrial motions, and today, finally, there was pretrial motions hearings over the last couple of weeks, and then finally today, the trial kicked off, and man, did it get crazy. The prosecution not playing fair at all. And again, this is exactly the stuff we want to follow and watch closely because justice is a process. It needs to be a fair, transparent process. The defense needs to have everything that they're supposed to have. They need to follow the judge's orders. State needs to follow the judge's orders, and they should have everything they're entitled to have. And the state of Georgia is not playing fair. Now, keep in mind, this will be the same district attorney's office that will be handling the Trump prosecution. So something to look at, and the ethics of this prosecution office is definitely lacking. So very disturbing stuff happened today in the trial. We're going to get into all of it. We're going to watch a little clip off Court TV that does a good job covering it, and we're going to react to it, talk about it, and get into all this. But the first thing of the day that we want to talk about right now will be the Donna Adelson surrender. That happened last Monday, and she was brought in from Miami. I did a little coverage of it. I did some shorts on it, but she was brought in from Miami to Leon County, where she was booked and held without bond, and she was presented with her three charges, which are the same three charges as Charlie. No trial date's been set, but there's going to be an upcoming hearing, I believe, in December, where they will discuss things of that nature. And you're going to get a status hearing, and they're going to begin the discovery process. If I had a theory, I'd say we'll see a trial probably come summertime, late summer, early fall of next year. But maybe it could be a little longer because I see the potential pretrial process and motions in this case to be a little lengthier because there's going to be a lot of talk about what evidence can come in and can't come in this case. But that happened, I guess, last Tuesday. She was transferred on Monday, and I had her arraignment on Tuesday morning. So our next topic at hand is the news that Becky Hill, the Colleton County Clerk of Court. Now this is huge. This is yet another revelation in this case that shows you that there is a lot to question when it comes to Murdaugh's verdict. Now remember, it's become significant now. You've seen the plan kind of come to fruition. Murdaugh is looking at 27 years, which he'll serve about 85% of the 27 years in state court. And then he'll end up, it looks like he's going to be doing some federal time. So the significance of this is that he is going to get to do the federal and the state time concurrent because he doesn't get credit for the federal time unless he's serving the federal time. Now, the state courts will recognize the time spent in a federal penitentiary. It's just the way it's structured. It's the way it's going to be. So as a result, he is going to go to federal prison. Now, the significance here is if he is back in court and he is able to win a retrial on the murder charge, he will potentially see the light of day before he dies. Because he'll be out. He's 50-something years old. He could essentially get a decade, maybe a decade and a half of time out at the end of his life, if he's lucky. So this revelation here that Becky Hill's son was charged with wiretapping court officials is crazy. It's got to get you wondering. Remember, Becky Hill was the one that brought information to the judge to get a favorable Murdaugh juror thrown off the case. That's part of the case against that Murdaugh's attorneys right now are exploring as part of the jury tampering allegations. Now we find out that she has her son, who was making $90,000 a year as the technology guru of the county, that he was using that position to wiretap people. This is absolutely crazy. So let's read this, guys. Let's go over this. Jeff Hill, the son of embattled Colleton County Clerk of Court Becky Hill, was arrested on Tuesday by South Carolina Law Enforcement Division agents on charges related to listening to other people's phone calls. According to court records, SLED formally charged Hill with wiretapping, intentional interception, use, or disclosure of any wire, oral, or electronic communication. And he was released Wednesday on a $20,000 personal recognizance bond, according to court records. Jeffrey Hill was the technology director of Colleton County government. The charges have to do with his alleged repeated misuse of county equipment, a source familiar with the case said. The arrest came after a long investigation, and one alleged victim in the case is a top-ranking county official. Hill has been fired from his $90,537 a year job, said Kevin Griffin, Colleton County Administrator, on Wednesday. According to an arrest warrant affidavit from SLED, the agency alleges that around July 20th, Jeff Hill did willfully and feloniously intercept electronic phone communications between two victims. The affidavit alleges that Hill was employed as Colleton County Information Technology Director at the time, and that he used his position to intercept and listen to a conversation between the victims. Neither victim was identified. The SLED document said that the conversation was recorded by a computer IP address that is assigned to Jeffrey Hill's computer. The victims were not aware they were being recorded, nor did they give their permission to be recorded, SLED said. A source said the cell phone of Becky Hill has been seized pursuant to a search warrant and is now in SLED custody. So this is significant, guys, because the fact that they're seizing his mother's cell phone means that she is involved in some way in this investigation. And with the timing of this, that this was around the time when everything was breaking on the investigation in regards to her behavior during the Murdaugh trial, one has to wonder, is all of this connected? And if it is, if we can prove that she is using her son, misusing her son, what else would she, again, this falls in line with the behavior that Murdaugh's attorneys are alleging. That doesn't mean she did what they said, but it certainly goes to frame of mind. It certainly goes to state of mind. It certainly takes away from the potential defense that says Becky Hill would never do something like that she doesn't act in that way or conduct herself in that way. It's very significant. Now, it's also, of course, should be noted that nothing Jeffrey Hill is accused of has been proven in a court of law beyond a reasonable doubt. Merely accusations have been made, and he is entitled to the justice process, fully acting, fully and fairly being transacted in his situation. So he is not guilty of anything at this point. So I want to make sure that's clear. Jeff Hill did not answer his county phone Wednesday morning. Court records did not list a lawyer. As a clerk of court earlier this year, his mother, Becky Hill, had a high-profile role in the Alec Murdaugh double murder trial, which was watched by millions on live stream on Court TV. An outgoing person, Becky Hill was a popular figure with the media and officials at the trial, and her duties included oversight of the comings and goings of the Murdaugh jury. A Colleton County jury deliberated less than 3 hours before finding Murdaugh guilty of the June 2021 murders of his wife, Maggie, and son, Paul, at the family's 1,770-acre rural estate in the western part of the county. After the trial, which lasted 6 weeks and ended March 3rd, Becky Hill published a book full of inside details of her interactions with the murder jury, court officials, and law enforcement officers at the trial. The book is called Behind the Doors of Justice. Since then, Murdoch's lawyers have accused her in court documents of jury tampering, allegedly influencing the jury behind the scenes to bring back a quick guilty verdict so she could publish her book with a neat cut and dried ending. The Attorney General's office has investigated those allegations and is contesting them in court. Hill has also denied the allegations in an affidavit. Murdoch's attorneys Dick Harpootlian and Jim Griffin have made the jury tampering allegations a key part of their effort to overturn Murdoch's conviction and seek a new trial for him. Attorney Will Lewis, a former assistant U.S. attorney who represents Becky Hill with Justin Bamberg, declined comment Wednesday. According to the Colleton County Internet site, the Colleton County Technology Department is responsible for all the county computers as well as telephones, conferencing, and mobile cellular services. At this point, SLED's arrest of Jeffrey Hill is not believed to have anything to do with the jury tampering allegations, a source familiar with the case said. A SLED press release said SLED was working on the case with the Public Integrity Unit of the 14th Circuit Solicitor's Office, which covers Allendale, Beaufort, Colleton, Hampton, and Jasper counties. The unit is made up of senior attorneys and investigators who review use of force cases involving police officers as well as alleged public corruption. So there you have it, guys. Look, this is significant. This is very significant in the standpoint to me about why her cell phone was taken. What does she know? Even though he may not be proven to have done anything in relationship to that trial, but it just tells you if she's aware of this, if she was having anything to do with this, if she in any way was asking him to do this, then this goes to the state of mind of this lady. Would she be willing to interfere with a jury to try to make money on a book? And that's the question that will be before a court, and this will be significant. So that concludes that coverage there of what's going on down there in Colleton County with Becky Hill. It remains to be seen whether or not this will directly link to Murdoch, but I still think whether directly or indirectly, and indirectly being the fact that you can't deny the fact that Becky Hill, from a character perspective and a state of mind perspective, this would demonstrate that she would, be potentially willing to do the things that Murdoch's attorneys have said that she would be. So anyways, so let's move on now. Those are the two kind of build-ups, the appetizers. Let's get into the fun one here, the start of Young Thug's trial. Let's get into it here. Let me bring this, and here we are. So we're going to start out with looking at the article today in the Washington Post, where it's reporting, the Washington Post reporting kind of my take on having watched. I didn't watch the full day of the trial of the opening statements. I've got to catch up on the final, I think, 2 hours. But what I watched was it was just nuts. And it really was disappointing to see the prosecution conducting themselves in the way they were. But let's take a look here what Washington Post has to say here on this, and then we're going to watch a clip from Court TV. So it says Young Thug's long-awaited trial in Atlanta got underway with opening statements Monday, but the day began with objections, delays, and calls for a mistrial. I am not happy about any of this, said Judge Ural Glanville on Monday after the prosecution's opening statement caused confusion in the courtroom. And that is an understatement, guys. It was absolute chaos. It was ridiculousness. They did not follow any of the judge's instructions. They were trying to hide the opening statement from the defense so the defense wouldn't be prepared. The defense turns over all their slides, pretty much everything that's going to be in their opening statements, but the state turns over 4 photos and says they didn't understand the judge's instructions or order. Absolutely uncalled for. So, of course, the defense attorneys begin to object. The judge gets angry. There's delays. The jury's thrown out of the room. It was absolutely nuts. But let's continue on, as this gives us good background into this case in case you're unaware of what it deals with. The trial's opening day arrived roughly 18 months after charges of gang-related activity were first brought against Jeffrey Lamar Williams, the hip-hop star known as Young Thug. Now, I did not know who Young Thug was. My young sons, informed me of who this was. In fact, my youngest son was the one saying, "You gotta go check this out. Young Thug's on trial," and that's what brought me to even check this out about a month ago. And then I got embroiled and started reading up on it, and it was like, wow, this is crazy. A 10-month jury selection. We're going to get to that here in a minute, but it's quite crazy. But it's also a great case to highlight exactly what we're talking about when we're talking about the justice process and the games that the state will play to try to deny a defendant's right to a fair, sometimes speedy trial, and they will try to violate the rights of the defendants in ways you're going to see here that they tried to do here today. And in this case, this is one of those unique cases where there are victims, but there aren't victims, because a RICO case is something that's a totally different animal than any other case. You're actually only having to prove in some cases that they only were thinking about committing a crime, or they'd conspired together to commit a crime on behalf of a group or a criminal enterprise of 3 or more people. And as long as they do that, and you can prove multiple acts that were made in an attempt to further, and by further they mean financially benefit the group and further the group's power or infrastructure or being, we'll say, then you can prove yourself a RICO case. It's very controversial. It was used against the mafia. One of the controversies is the standard of proof sometimes isn't as high. It's not as clear. And they get to put in a lot of other evidence, and evidence that if they were just trying them on one specific charge would never get to come in. But judges are allowing it. The United States, the federal courts have allowed them to go forward, and Georgia has adopted a very controversial RICO law that potentially could find its way, and in Trump's case, it was almost finding its way into federal court, where some of the aspects of the Georgia law that need to be looked at and reviewed could become problematic for Georgia in going forward on how they want to process a RICO law. But anyways, eventually, one of these cases will find its way through the appeal system, and it's going to get, tried and tested. But today, as you can see, the prosecution is also not just to test out the law. They're going to be, their behavior is testing the bounds of what is ethical and what is fair. Williams was one of more than 24 defendants charged with conspiracy to violate Georgia's Racketeering, Influence, and Corruption Organization Act in May 2022, as well as participating in criminal street gang activity. The rapper faces additional charges, including 3 counts of violating Georgia's Controlled Substances Act, possession of a firearm while committing a felony, and possession of a machine gun. He has pleaded not guilty to all 8 counts. 6 defendants, including Williams, are standing trial. Fulton County District Attorney Fannie T. Willis has alleged that Williams was associated with a Bloods-affiliated criminal street gang called Young Slime Life. The allegations suggest that the artist's rap lyrics often use the acronym YSL, the initials of both the gang and Thug's record label, Young Stoner Life Records, and other alleged criminal activity. Prosecutors intend on using the rap lyrics in the court trial. Now, that, guys, that is another novel thing that we've seen, or that's a part of this trial. This is the first time a prosecutor is attempting to use rap lyrics in the way they're using it, which is they are trying to use the lyrics in the song to establish that these rappers are part of a gang, essentially part of a criminal enterprise. Willis used the same RICO law to indict former President Donald Trump and 18 co-defendants in connection with their alleged attempt to overturn the results of the 2020 election. Adrienne Love, the chief deputy district attorney, made the opening statement on behalf of prosecutors Monday, saying that Williams and the other defendants partook in gang-related activity for years. YSL checks all the boxes for being a criminal street gang, she said. Defendant Jeffrey Williams was its proclaimed leader. Now that's Young Thug. She said YSL, as the evidence will show, didn't move individually. The members and associates of YSL moved like a pack, with defendant Jeffrey Williams as its head, Love said. Her opening statement was interrupted as Williams' defense team called for a mistrial after Love's presentation tied Williams' attorney to a separate case. And this is where the chaos absolutely got crazy, and we're going to watch some videotape of what happened here, which Judge Glanville had previously ordered against. The defense said it had not seen several slides in her PowerPoint presentation, despite court orders to exchange the materials that would be presented after a lengthy back and forth, which included other objections from the defense to material in the presentation. The motion was denied by Judge Glanville. Now, this is the stuff that we're talking about here in terms of prosecutors not playing fairly and trying to subvert justice here. They're saying they're working for justice, right? To them, a justice is a conviction, but it's not a conviction. Justice is fairly presenting the evidence that they say supports the charges that they've leveled against Young Thug and his other defendants. It is not playing tricks. It is not providing information or trying to provide incorrect information to the jury. Still, multiple attorneys representing the defendants called out the factual errors within Love's opening statement. President Love's opening statement presentation slides and called for them to be removed from the case. And this is where things got really, really crazy and they spent hours going through these slides and arguing over these slides. The judge was beside himself. We're going to watch some of it. It's unbelievable. The delays Monday morning followed multiple postponements in the trial, which has drawn national attention for raising the questions about how rap lyrics could be used by prosecutors in legal disputes, because this is going to put other rap artists potentially at risk. Several delays postponed the trial, including a lengthy jury selection, as some potential jurors had to leave the case over its potentially lengthy schedule, according to the Associated Press. On November 1st, a jury of 12 people were selected for the trial after 10 months of jury selection. Never mind. Sorry, I was reading an ad. Williams was first arrested on May 9th, 2022, and charged alongside 27 others, including rappers Gunna and Yak Gotti. Several of the defendants took plea deals, including Gunna, an Atlanta rapper whose real name is Sergio Kitchens and had a close association with Young Thug. Prosecutors argued that Young Thug, Gunna, and other rappers charged in the case hinted at criminal behavior through lyrics in their songs. The defense, as well as civil rights attorneys, have argued that lyrics are an example of freedom of expression and that targeting rap lyrics is also an attack on black art. The legal dispute paused a growing career for Young Thug, who has seen 3 of his albums hit #1 on the Billboard 200 chart. He has been in custody since being arrested in 2022. The rapper, who has collaborated with artists like Drake, Travis Scott, and Nicki Minaj, has been nominated for 4 Grammys and won Song of the Year for his 2019 songwriting work on Childish Gambino's This Is America. Attorneys for Williams and the Fulton County District Attorney's Office did not respond to multiple requests for comment. So it does make you wonder that if this gentleman, with all the success that he's been having, continued to engage in criminal activity, continue to engage with people that were active in criminal activity, why? You're making all this money. You've got a legal, lawful way to earn. Why do you need to continue to rely on criminal acts if that's what you were doing? Now let me get the video queued up here. Give me this video, courtesy
first
of
thing that Mr. Steele
Court
has
TV.
requested of the court regarding the representation that the state made about other YSL members contacting Jeffrey Williams for representation is absolutely and has always been a part of what the state expects will show at trial.
I'm going to deny that portion. But to Mr. Steele's point, I'd already made that issue in terms of his particular involvement, and anything you need to let me know prior to that. And I need to rule upon it, and also subject to foundation, and just like this. So I assume that what you told our jurors is what you expect the evidence to show. Yes.
Yes,
All right,
definitely.
so I'm gonna overrule that part of his objection. What about the last thing you mentioned?
And Your Honor, as to the court's directive that we turn over anything or any exhibits or photographs, that was my understanding of the court's directive, that we expect to show an opening statement.
And it's
as a matter of course,
to get frustrated.
I can again reiterate the fact that it was an inadvertent omission to leave Mr. Steele, at least part of his name on here.
I got that, but he's talking about, is there anything else you're going to use in opening you haven't shown to defense counsel? He's telling us. I said that. I told you to do that a week ago. Because here's what I told you was going to happen. I've got a jury that's out right now that's being interrupted. And Mr. Williams, you should have made your motion or should have told me about that an hour ago or when you found out about it. Not hijack me at the bench about that. You did what you had to do, but I'm not happy about that. I'm not happy about any of this. Because this is stuff we could take care of before our jury comes in. And that makes you all, lessen your ability as advocates and lessen our ability for this jury to go ahead and get this case seamlessly. This is what I told you all was going to happen.
And see, these are the things prosecutors will do. But this is wrong. This is not justice. This is not it. Being fair. This is not presenting evidence in a fair way. If you've got the evidence to prove your charges, you don't need to do these type of tricks. You don't need to withhold things. Just, hey, put it out there. Let the defense be in a position to ask the questions they need asked. And if those questions lead to doubt and lead to reasonable doubt and lead to your case not being proven, so be it. But this is where the gamesmanship, this is where the gamification of the justice system has happened. And these guys, these prosecutors, these attorneys are more worried about winning than they are about ensuring justice. And justice being a fair showing of the facts and the evidence and allowing the jury to make the determination based on what the evidence and facts are, not underhanded, sneaky facts, not an underhanded, sneaky version of your case. Anyways, let's get back to this.
So, have you given them everything you're going to show them during opening statement?
Your Honor, I haven't given them all of the word slides. I did give to them what Mr. Williams objected to. I had given that to them previously. I will give them or share with them the things that have been added as of this evening. And
can you do that over the next 5 minutes?
I sure can.
Can you find out if our jurors are ready? Are they ready? Are they still using the restroom?
I'll send that to them right now as we're waiting.
Your Honor, we have a few remarks.
Your Honor, Jay Apt on behalf of Mr. Kendrick. Can we have 5 or 10 minutes to review whatever Ms. Love is going to send us?
You can take a comfort break, and I'll come back at 10 of 12. And like I said, whatever we don't finish before 12:15, we'll pick up after lunch. Okay?
Thank you, Your Honor.
Who's talking?
That's Sharp.
Yes, Mr. Sharp.
On behalf of Mr. Stillwell, we've been operating pretrial with the Harvey rule. I want to make sure that the record is clear that we join Mr. Steele in his motion for mistrial. And if Your Honor,
I'll apply the Harvey rule unless you tell me otherwise. Okay?
And that will apply throughout trial.
Yes.
Okay, thank you.
Unless you tell me otherwise. Okay? All right.
Thank you.
All right, we're going to be in recess about 10 minutes, all right?
Your Honor, what I'm going to do before sitting is I'm going to actually do a search.
All right. This was just a bit ago, and so you could feel the tension starting to rise. Kelly, have you ever been in a situation where you're delivering an opening and you get objection after objection, and then the jury actually gets sent out?
You don't ever want to be in that situation because it ruins your flow.
Yeah.
And so then when you have someone that keeps objecting to what you have in your head, you just, in a way, you can lose your place. I mean, you really have to know your opening statement or you're going to get messed up. And you can see here the prosecutor is just really trying to defend some of her actions here, saying that maybe she didn't supply every single detail, but tried to. We're going to have to see what the.
Let's be clear here. The prosecutor is definitely trying to defend her actions. Although I wouldn't say defend her actions. She's trying to justify why they're playing games, why they didn't like the judge's ruling. And the defense, see, what you need to make sure you understand here in this situation, the defense turned over everything. They turned over their slides. They turned over everything they were supposed to turn over. The state turned over 4 slides of photos that they were going to use, and didn't turn in the rest. And I guess said, you know what, we'll roll the dice. There's no way. And again, I'm not sure if they're what parts they're going to show, but if you're watching the entirety of the incident, they're going to say, hey, this doesn't rise to the level of a mistrial. And while the remedy for this probably isn't a mistrial, and they knew that, they figured we'll take the instruction, whatever remedy the judge wants to do. It won't be a mistrial, and we'll get away with this, and that way we will retain the advantage. But these are the things that, look, this is not fair. This is 100% not fair, and is 100% not the way this process should go. And these prosecutors should face sanctions. And ultimately, in my opinion, they should not have been allowed to use that slideshow. But ultimately, they ended up being allowed to use a version of it. There were problems. We're going to see how all of that progresses. Let's jump back in.
The judge says, but clearly he is not happy.
No, he's not. And it was clear that he had ruled on this
rightly
recently,
so.
like within the last couple of weeks. So he remembered that he had ruled in a certain way. And it seems like the prosecutor's definitely backpedaling a bit. All right, let's go back now and pick it up after that little break. And the argument continues. The jury's still not in the courtroom.
Including things, but Your Honor, that is not an intrinsic act in the sense of it being a crime or criminal act, and it is what the evidence is going to show happened. What I have in the PowerPoint, I can show the court if you like. I sent that to defense counsel prior to today. I think I sent it Friday before 5. But what I have said is that on the day that Shamel Drinks was, I'm sorry, Jamari Holmes, my apologies to the court and to the family members here. What I said was that on the date that Mr. Holmes was gunned down, 12 hours after that murder, Mr. Ryan posted on his Instagram account, I bet YSL makes the news. And what I endeavored to say to the jury, that the evidence will show is just that they were advertising and representing and boasting on behalf of the gang itself immediately after the murder occurred. And these are elements that court.
Now, my issue with the state's contention here and with them, is YSL was also as you heard in that article, is also the name of the record label. So, if you're are you going to start calling record labels gangs? I mean, this is a dangerous spot to go into. Obviously, we need to hear the evidence, but the point is, I don't know that the social media post, this is one of the things we're going to see evolve here, and one of the issues that's got to get raised, and is being raised, has been raised in pretrial, and is being dealt with. And this is one of the reasons why the witness list has expanded exponentially, is because they have to lay a foundation for what that was, what that is, what they meant by that. They can't just throw that in front of the jury and say, oh, this is about a gang. They've got to lay a foundation. They've got to have a witness come in and testify. Now, little background on this situation. They had 21 defendants, okay, one of which is still not in custody. There were 20 defendants at the start of this trial in January. They are down to 6, okay, because the rest of them all pled guilty, took deals. One of them's on the run. So this case is going to be a very interesting case, because you're going to get a lot of testimony here that's going to be bought testimony by the state. In other words, the state is going to have sold out to these people that are testifying and given them lesser sentences, excuse their behavior for what they would say in their eyes, worse actors, right? The more the worst actors being Young Thug and the other 5 individuals that are on trial, saying they did worse things than these people did, and therefore we're willing to give them a little break. These people are cooperating. They're willing to do good acts to try to offset their bad acts. But I think it's going to be an interesting case, and this is why this is going to be one we are going to be following. Now, because it's going to be potentially going on over the next few months, we're going to obviously be following other trials as well. I'm going to be watching, keeping track. We're going to be updating on this and watching as key pieces of evidence come in, because this is something that is going to be interesting for several things. It's tie into President Trump's upcoming trial that he'll have in Georgia, getting a look at that process and how these prosecutors are going to conduct this trial is going to be similar to what they're going to be doing in that trial as well. Let's get back in here and check out the rest of this.
I believe we'll hear from detectives and evidence. These are things that the courts have said jurors and the courts should look to in determining whether something is done in furtherance of a gang. And so I would ask the court, I did take it out as the court instructed. I would ask that the court allow me to make reference to it. And thank you, Your Honor, for your time.
All right, Mr. Williams. Oh, sit down, Mr. Adams. You can just wait a minute. All right, Mr. Williams. What's your response, madam?
That the court already ruled on that, saying that you would bring it up as it comes forth. You stated that they couldn't use it in the opening, and I would just ask that the court use their instruction and make the state follow the instruction that the court already gave.
Okay, but it may not be what I think that Ms. Love is saying, Mr. Williams, is that the evidence may not necessarily be intrinsic. It might be for another purpose, is what they expect the evidence to show. So, but here's the issue that kind of I'm disappointed is the court. You all could, we've had months and months and months. We could have taken this up before. I could have made it very clear. I don't need to take it up right on the eve of our jury sitting in the box. That's what I'm kind of more annoyed with than anything else. If you had clarity or wanted to seek clarity on that, I'm more than happy to rule on it, but I needed to go ahead and have some ability to do so. So I don't think it's intrinsic. It may be for other purposes, and I'll let the state reference that if they have a good faith basis to, that if they believe that's what the evidence will show. Okay?
They put it in their motion as.
Say again, madam, I'm sorry.
They put it in their motion as intrinsic evidence, though. So they shouldn't have put it in their motion if they were going to.
Yes, ma'am, I would probably agree with you, but did I have a rule on that issue?
You said that you would do it later as it came.
Okay, well, here's the thing. Later is now. I got a jury in the box, so you could have asked me that an hour. I mean, we had time this morning. I could have gone through that this morning and made clarity on it.
So the judge gets called out, and she's making a good point. look, he deferred to ruling on it. He's complaining that it wasn't raised earlier. It was raised earlier. It was listed in the motion as intrinsic evidence. He defers it and says he'll rule on it later. Later is now, like he's saying. So what is the problem, Your Honor, of you dealing with this right now? Problem is the judge is upset with the prosecutors, but he doesn't want to hamstring the prosecutors, because a lot of times judges, when you have to make an unpopular decision, like what they're asking, which is you shouldn't be allowed to use your PowerPoint. You didn't follow the rules. I guarantee you, if this was towards the defense, he would have no problem saying no PowerPoint. But because it's the prosecution, he doesn't want to hurt their ability, but he wants to also say, listen, I'm going to take a stand. Let's put him in a bad position. And he's getting angry. He's not making much sense. The good news is, I mean, well, I guess it's not good news if the defendants get convicted, but there is recourse. And the judge also has to step around the idea that he knows that if what he does results in the defendants getting convicted, and an appellate court comes back and says, I disagree with what you're doing, he could get reversed. Judges don't like to get reversed. So he's in a situation right now where this trial is just beyond out of control. You've got all these, and again, I see the same thing happening during the Trump trial, because there's going to be a lot of defendants, and it's going to be a mess. We'll see how they conduct themselves. But let me tell you, this judge has a major headache on his hands. Let's keep watching. It gets crazier
For both sides. But do you have any other basis for the ruling? I mean, for my ruling, not any other argument?
No, just I wish that the court would just follow their own instruction.
Well, I'll follow my instructions when you all bring to my attention what you need to in a timely manner, okay? And give me the full breadth of, so I can rule upon it accordingly. That's what I'd like you all to do.
Well, they also have slide 45. They have my client's name on there as gunning down a 23-year-old Shymel Drinks. And my client has nothing to do with that. But I didn't get that
Ms.
slide
Love says
presentation earlier.
Ms. Love says she is going to remedy that and exclude it.
Thank you, Your Honor.
Okay, all right. Now, Mr. App, what is it you want to tell me?
I am so sorry, Your Honor. But thank you for allowing me to speak. I do have an objection, Judge. So, Ms.
What's your objection specifically, sir?
Attempted to email us during the break the PowerPoint slides that she is using in opening. I could not open the attachment. I brought that to the attention of her co-counsels and staff, and Mr. Matthews was able to open it.
Be sure to listen closely to the judge's instructions here before they go on break again.
At least a dozen
Just listen.
more slides that were never turned over to us, even though the court instructed us to share with the state and for the state to share with us prior to opening any exhibits for opening argument. And so, I mean, these are all new to us, and I would just ask that the ones that she did not share, she shared 4, that the ones that she did not share be excluded. I'm objecting because the court ordered for us to share these. She did not. Clearly, she did it intentionally. There's also apparently factual errors in them. I would ask that any slides that haven't already been shown to the jury and that she did not disclose be excluded from her opening.
Yes, 100%. Good job.
Yes, ma'am, and then I'll go on to the next person.
Thank you.
Yes.
Your Honor, I did not send only 4 slides or attachments. I sent to counsel for the defendants the photographs, the evidence that I intended to put into the opening PowerPoint. As far as the state's theory of the case and theme of the case and the words that I wrote, those are things that were being developed, ongoing, and I did not understand the court's directive to me that we needed to turn over the words we would be speaking. As far as the photographs go, Judge, I said to them, if they can, actually, I sent them to them. So there are some, I have only about.
Your Honor, they're done.
Hold on, wait, let her finish, and then I'll let you respond, Mr. Apps.
So all of these slides that involve Christian Ebinger, I sent to them. And other than the slides involving Christian Ebinger, there is a slide of the vehicle that Donovan Thomas drove on the day he was gunned down is the back of the vehicle with the placard of showing the bullet defects. That will be shown. There's no one that has made any objection to that evidence being introduced at trial. Nothing that I have put in the PowerPoint includes anything that has been objected to.
Look at the judge over there. He is getting very upset because she's basically saying she didn't follow his order.
I'm not certain if this app thinks that we only served 4. Maybe, I don't know if he had trouble opening it up, but we served, I think, all of them. If not the
You think all of them. You should know all of them.
I don't even have 20 photographs in this PowerPoint. So everything, and I can show the court, I will share it if I did not, with the court as well. But these photographs, I have a picture of Jonathan Thomas in life. I have a picture of the barbershop where he was gunned down. I have a picture of the back of Jonathan Thomas's Tahoe. I have a picture of Jonathan Thomas's headshot. At the time of the autopsy, no cutting, no nothing, just his face with the number. I have a picture of, as I stated earlier, Your Honor, the truck with the defects noted. And then I have pictures of Christian Eppinger.
And we're going to speed this up a little bit here.
Provided, and that's the extent of it. The majority of the slides have my words, my work on it.
All right, Mr. Adams, before I go ahead and respond.
Your Honor, no one's suggesting that she has to turn over the text of her opening argument, but if she's going to show a PowerPoint to the jury, that is what the court instructed us to share. We're visual exhibits, and that's what she's doing. She's placing it up on a screen for the jury to see. And whether that's her own words as part of her opening as a PowerPoint, or it's just demonstrative, she could have shared it, and she didn't. And she did it. And she's suggesting now to the court as a work in progress that she hasn't worked on her opening statement until this past weekend. I don't believe that. I think she's.
I don't either. I do not either. Put in the comments if you believe it.
If it's not the case, and she didn't mean to mislead the court just now, then she could have and should have shared those PowerPoints. As to the photographs, those also could have been shared with prior to opening. If there's no one's suggesting they're not admissible at trial. If they're admissible, she can admit them at trial. But to show them to the jury now is part of her opening that violates this court's order that we were supposed to share our exhibits for opening prior to trial, which she did not do. So I think they should be excluded from the opening.
I agree.
If she wants to introduce them later as evidence during the course of the case, then so be it. But I think there is good grounds for this court to, and Your Honor got upset because these issues could have been handled. They didn't have to wait until now. This is wasting time while the jury's waiting. Your Honor's right. And it's not our fault. It's her fault for not doing what the court instructed. And as a result, the appropriate and reasonable remedy is to prevent her from sharing any of these slides with the jury that she did not share with defense counsel prior to today.
He's right. He's right.
What a heated start to this trial.
It's going to be a long one.
It is going to be a long one. Oh, wow. We are going to get in a quick break, and we will get you back for more arguments just in a few minutes. Stay with us. You're watching Court TV Live, your front row seat to justice.
Howard Murdoch, convicted double murderer, just accepted a plea deal from prosecutors.
How do you plead?
I plead guilty, Your Honor.
He stole the money from Tony Satterfield for $1 million of his own client's settlement. Why did you agree to that? This unbelievable fault from
We're going to speed this up a little bit here.
Murdoch stolen million sentencing. Live coverage Tuesday morning, 8/7 Central on Court TV.
Welcome back to Court TV Live. The trial for rapper Young Thug is underway in Atlanta today.
The Georgia jury will have to decide whether Young Thug is the kingpin of a violent street gang called Young Slime Life, or YSL.
The defense claims Young Thug has no association with any street gangs and that YSL is just his record label name.
Now, all morning long, it started with the state's opening statement, but after about 30 minutes and a few objections, the judge had to actually let the jury out of the room. And now it has been about an hour since the jury was in the courtroom. They've been going back and forth, arguing about some demonstrative items that the state put up on the screen. The defense had not seen. The ruling was everyone was going to share. And here we are. Let's bring in criminal defense attorney Elizabeth Baker. She's been watching all.
So here we go. We're going to get a little
Elizabeth?
input here from a defense attorney.
Well,
Let's hear
I'd
it.
say, the L word has been thrown around the courtroom already, which is pretty interesting, just straight out accusing the prosecution of lying about, having this be a good faith error.
And I think
I think the judge is just getting more irritated
well-founded.
is what is going on. And it is not good trial management. And this is because the prosecution failed to share these things. When the judge remembers the ruling, it is not a good sign for the prosecution.
No, Elizabeth and Ted had asked me if I can recall a time during opening statements where somebody was objected. And I had to go all the way back to my first practice in law school where another student got up, kept objecting, and I was getting frustrated. But then you learn. You want to take measures to make sure that doesn't happen again because it can really throw you off. Here, in this situation, we had the prosecutor that clearly, according to the allegation here, did not follow the judge's order. And so in a way, it's throwing her off. Now we're in the situation where this is being delayed even longer. Can you kind of just speak to that and what this means for her case going forward?
Well, I think at a minimum, it means that the defense is going to be watching her very, very closely. You can see their frustration, the way they're voicing their objection to the court. The court is growing more frustrated because it really is a management problem at this point. And the judge's focus is on jury comfort. The jury's back there. They're already starting to think about stuff that the judge doesn't want them to think about for quite some time. It just doesn't bode well for the flow of this trial at all. I think the defense objections are well taken. They're not being superfluous. They're not, I think they're stating it very clearly. It's a problem. She sends the exhibit to them. They can't open it. Whoops, judge, sorry, I had no idea. That's just not a thing.
Yeah, I mean, the fact that the judge did rule that they have to share, that seems pretty evident by the back and forth there. And then there are more slides than what was shared originally, and then final share. I mean, it is turning into a nightmare. And it started with a missing juror this morning, so maybe that was the beginning of what is going to be a clunky, at least first day. But so go back in, we're going to pick it up again. The jury's still not in the courtroom, arguing attorneys and the judge in the middle.
Evidence for whether their text is hard proof.
All right, Mr. Matthews?
Yes, Your Honor. Good morning to the Honorable Court. I'd like to direct the state's attention to slide 15. In slide 15, the third bullet point, it references October 1st, 2020 in terms of that quote from the text message. In the indictment, Your Honor, if you look at Overt Act 102, that's where that particular quote comes from, Overt Act 102. And Overt Act 102, the date of that alleged text message was March 12th, 2020, not October 1st, 2020.
We'll speed this up just a little bit here.
The quote in the indictment is different from the quote.
They're going over the inaccuracies in the slides.
Slide 16 is the Overt Act that's alleged in the indictment as Overt Act 123. In the state's opening presentation, the date they have is October 1, 2020. But in the indictment, that particular Overt Act is November 16, 2020. So that's the third error in the state's opening slide presentation. So those need to be corrected to mirror the indictment so that it's not misleading the jury and in fact giving wrong information to the jury judge. So I'll ask the state correct that, remove it, or correct it.
All right, anybody else? Yes, Mr. Short.
On behalf of Mr. Stillwell.
Speak up, please.
On behalf of Mr. Stillwell, slide number 37, it suggests that Mr. Stillwell is still committing crimes on behalf of the gang, even after being indicted on these charges. We began to discuss intrinsic acts and other unindicted allegations last week, but we did not get through it. And my understanding was that anything that you had not ruled upon, we were not supposed to reference or discuss in opening statements. So those are clear references to unindicted charges that we.
Now, I want you to understand something important that this gentleman just talked about. I mean, and this is incredible because you figure, as you've probably seen, if you're a trial follower, you see trials last a couple of days normally. They have motions that are unruled on. They have areas that they're not even allowed to talk about because they're anticipating they're going to be figuring out these motions in the coming weeks. So that just tells you what a mess of a trial this is, how long this trial is intended to begin, and what a unique type of trial this really brings to the table. To me, if I'm the prosecutor, I've got to be really worried about whether or not this jury is going to pay attention and be able to pay attention, be able to understand what it is they're saying, and remember all the things. I mean, they're in the middle of their opening statement. They're 30 minutes in right now, and this jury, isn't hearing anything and doesn't hear anything for several more hours because they're going to break for lunch, and this goes on and on and on for another couple hours. It's absolutely ridiculous and unbelievable that the state would act this way and that the state would feel that something like this is acceptable. Let's get in and finish this up here. We've got about, 4 more minutes if we run this at 2 times speed.
Did not get a ruling on its admissibility yet, and I would ask that just be taken out of the presentation and no mention be made of those.
Anybody else? Yes, Mr. Steele.
Thank you, sir. If you look at also number, I'm looking at now, 48, 49, 53, 54, 55. As you are prerogative, that's the original reason that's law.
Could the court allow Mr. Steele to repeat those slide numbers? Because what I think they referred to is something that I placed in here that the court said during preliminary instructions to the jury. And it was regarding the court, and that's the last thing the court said. And all that did was put on the slide judge's bar.
In terms of what slides are you talking about, Mr. Steele, again?
I have 48, 49, 53, 54, 55.
So 49, 48 through 55?
Excluding the 48, 49, but it's here, 53, 54, 55.
48, 49. You want me to share the Zoom on the slide that Mr. Steele?
I would, yes, please.
Thank you. And you said Mr. Steele, 45?
Just share the presentation, please.
All right, the argument continues outside the presence of the jury. A clunky start to the beginning of this case. We'll get a break in here, get you back to the courtroom for more right after this. Back for it to be live along with Telegraph. I'm Ted Rowland. It's been a very interesting morning and now early afternoon.
Yes, Ted, we are bringing you the Young Thug RICO trial that's happening out of Atlanta, Georgia. The jury has been dismissed as the two parties discuss issues with the state's opening statements.
Yeah, and the young thug whose real name is Jeffrey Williams. 5 other defendants also there. They're all facing gang and racketeering charges. Prosecutors say this group has violent a number of gang-related crimes spanning the course of a decade. Let's go back, pick it up again. No jury, just attorneys and a judge.
Your Honor, showing on the screen slide 48, which is the last thing in the court.
Take notes?
Yes, Your Honor.
All right,
And
49.
That was 30 from the court.
All right, 50.
50.
It's not 50, sir, 53.
53. Let's get down to 53.
What this should be underscoring for you, the reason why I'm showing this, and I know it's a 2 times speed, but what hopefully you're seeing here is the amount of issues with these slides. And the reason why the judge wanted these slides put forth ahead of time was to allow the attorneys to do this. The state wanted to circumvent this. They wanted to be able to just send these over to the defense. They were anticipating that they would do a corrective, a curative instruction and go on. The judge, of course, has said no. And of course, you've got a room full of high-powered, well-paid, very experienced attorneys. And the attorneys are saying, no. We're not glossing over this. We are going to go through. And of course, the judge, unfortunately, he doesn't have attorneys that he can push around, mainly because there's so many defense attorneys in the room. They're not going to let him. If one, he might get over on one, there's going to be another that's going to stand up and say, not me, not happening, not now. And that's exactly what you saw happen when the gentleman in the front stood up and said, no, I'm speaking up. These need to be thrown out. They will not be discussed in my client's case. And that caused, of course, then other attorneys to jump up and go, well, you know what? I better jump in here too. And now we have this. And it was just an absolute free-for-all. And I'm going to play a little bit of the clip that happens after lunch where the judge loses it completely. But let's get through this part here and finish out this video, and then we'll get into the next part.
And 53 is what I said the evidence is going to show. So I want to, in speaking to jurors regarding the witnesses and instructions that the court has given them, I want to say to them, some of them, as I already alluded to, some of them may not be wanting to speak. Some of them, you're going to be evidence that some of them are afraid, some of them are embarrassed, some of them are intimidated, some of them don't remember, some of them don't want to remember. That's simply what the evidence will show. And what I'm asking that the jury does in listening to and considering the testimony of any such witnesses is, as the court has already instructed, which is just to use your common sense because you own the side and you believe. We're asking you to listen carefully, take notes, and get it from. So there's nothing in that slide 53 that is in any way infringing on or entering to a lane that does not belong to the state. We are entitled and allowed to show and state to the jury what the evidence will show. The way that I have decided to represent it in writing makes it no less so.
Yeah, but it borders on argument at this point in time.
So I can change it because I do expect that the evidence will show that some of the witnesses are afraid, some of the witnesses are embarrassed. So I can take out.
Well, that's different. You might want to just redo it.
I can do that.
Any further objections, folks?
Yes, Your Honor. I went over to the state's table, Carson Matthews and Beatrice Steele went over to the state's table and brought to their attention an error in slide 42, and I think it's incorrect.
All right.
Is that correct?
Here's what I'm going to do.
Now listen to this. This is very important.
Exactly why I told you. I wanted you to, and let me go ahead and just say this, Ms. Love. I told you to give them your PowerPoint presentation. This is why you give it to them, so that they can get errors and they can also figure out if there's something they object to. So this is what's caused this delay. Because at this point, like I told you, there's no secrets in the trial of this case. You all have gone through quite a long process. But this just highlights the concerns the court had in terms of just breaking up the presentation for our jurors. So what I'm going to do, ladies and gentlemen, I'm going to go ahead and call our jurors out. I'm going to go ahead and release them for lunch. I'm going to tell them they're going to be at lunch until 1:30. During the lunch hour, Ms. Love, I want you to play for the slides that you have that otherwise have not been shown. You need to show them to defense counsel and make sure they're correct. In the absence of them being corrected, I'm going to exclude your presentation.
They have the presentation.
But it needs to be correct. I don't want, if I get another objection about an error, I'm going to exclude it for the purposes of the opening statement because you didn't follow my instructions. This is why I told everyone. They need to get and the defendants needed to give you their opening statements and the things they wish to use during their openings as well, because we're having interruptions and delay, and that's what I wanted to avoid for our jurors. That was the reasons I told you all to do that. So,
Your Honor, as far as any typographical errors.
I'm not worried about that. But I'm not worried about that. But the errors that Mr. Abt, Mr. Matthews, and Mr. Shaw have made are errors, and Ms. D. Williams need to be corrected. Okay?
Yes, Your Honor, I will, of course, correct.
And but everyone else needs to see it so they can be comfortable and make sure that you've represented something that what you expect the evidence to show to be correct. Okay?
Thank you, Judge. Will do. And Your Honor, I also wanted to point out to the court that even if I misspoke, the court has already instructed the jury and will continue to instruct them that nothing I say is evidence, and if I misspeak or miswrite,
but that's not the point. I'm gonna tell them that, and I told them that already. But that's not the point. The point is so that we can have a smooth and orderly presentation of evidence. Okay? So, all right. Sergeant Ingram, can we go ahead and call for our jurors, please?
All right. So I have a clip here. We're not going to watch this entire proceeding here, but we're going to get into watching this. This is where the judge absolutely loses it. And actually, at one point, he says, we're excluding all of them. Now, I think that's what the judge wanted to try to get to, was he wasn't comfortable saying, prosecution, you can't use yours. But he gets here where the defense attorneys didn't follow his instructions, or at least he says they didn't. And, well, let's watch it, and then we'll talk about it.
Your Honor, I was unaware that there were changes. I apologize. No one told me that and gave me an email to that or a text.
I told you all to do that during lunch. That was my last conversation with you all before I went ahead and broke for lunch.
That's what I've been doing. Been waiting. I've been right here. In the hallway and in that other room again. So I understand that the state updated something and not realize that that's what they were doing.
Your Honor, we heard that they would be making those corrections.
You know, you all don't listen to the court, and it's going to get you all in a lot of hot water. You need to listen to me when I tell you something, and don't rely upon your own understanding. If you have clarification, ask me at that point in time. I'm more than happy to do that for you. But that's not what I told you all to do during the break. These jurors are waiting back there. We are dallying out here. So, you didn't follow my instructions, Mr. Steele. I mean, that's what I asked you all to do. I asked you all to share each. We're already behind to begin with. So, objections?
Yes, Your Honor, I didn't know that they were changing.
Yes, Ms. D. Williams.
And on slide 10 and 13, they misquoted the Instagram post.
They misquoted it?
Yes, they did. It says, I bet YSL make the news tonight. That's not what the Instagram post says.
Your Honor, we actually
I mean, the incompetence is unbelievable
into
here.
slides 10 and 13.
And it does not say tonight.
I'm sorry, okay.
I mean, this is embarrassing.
I will take out the word tonight. He's right.
Anything further? Mr. Shard, did you rise to?
Well, I'm just seeking
On behalf of, I think, everyone in this back row, we're seeking clarification. Is the state saying that the same link that they sent earlier before the changes will now show?
This is when the judge really gets nuts. Watch. Ready?
In fact, it does. It has on every other person's computer who has this PowerPoint. And at the appropriate time, we would, Mr. Sharp shared his PowerPoint. We were able to see it, and the state has objections to the argument slide in Mr. Sharp's PowerPoint that we would like this record for.
Yeah, here. Could you repeat that, Ms. Love, again?
Yes, Judge.
Mr. Harvey can't hear back there.
So the state shared its PowerPoint with all parties, including other members of the state's team and the other members of the state's team that have looked at the PowerPoint. They were able to see in real time the changes that are being made, as are anyone with the link that I shared with the defense earlier. Additionally, Mr. Sharp, over the lunch break, shared for the first time his PowerPoint and has included slides to which the state objects and has responded and told the court and Mr. Sharp that we object to. But I just wanted to make the court aware before we were in front of a jury again, as this, I think, is the appropriate time to do so. But the changes that the state made were available and published to everyone on counsel for the defense team.
All right.
Okay. I think the confusion, Your Honor, I understand what the state's saying now. The confusion is no one on the defense team we were waiting on a new email with the new version of the House.
That's not what I told you all to do. I was pretty clear. I said, y'all over lunch, just take a look at the state's PowerPoint.
Do you feel
make sure you have no further objections. I didn't tell you to go email it to you. I just told you to look at it. I don't care how you did it, but that would be the thing I would probably have gone through and said, hey, let me see slide 1, 2, 3, 4, 5, 6, 7, 8, 9, whatever else.
Okay. We were waiting. We had voiced some concerns already, and we were waiting on the new version. And I'm just explaining, Your Honor. I don't think anyone was aware that it was being edited on that old link. I think people were waiting on a new version of the PowerPoint.
Okay. Here's what I'm going to do. I'm excluding the PowerPoints. Y'all are just going to have to make this thing up the whole way. Yeah, just make an opening statement.
Now watch what happens here.
Let's bring our jury.
Defense is going to get crazy. Watch.
No PowerPoints because you all did not do one. I'm starting. You didn't do what I told you to do, and that was to exchange PowerPoints. We have wasted almost 2 hours trying to get this stuff done, and my orders to you are not aspirational. They're given for a reason, and when you don't follow them, then I have a way to remedy that. So the remedy is nobody uses no PowerPoints. Okay.
If I could address the court, our Matthews from Mr. New. In terms of what we have done here on our team, we have provided our opening statement to the state of Georgia, as well as to every other person on the defense side. We have received from the state of Georgia an updated came to my email from the state of Georgia with the changes as it relates to Mr. Hugh. I have it. I will be hamstrung, Your Honor, if I am not able to use my opening statement because I prepared my case with my opening statement. I have not committed every single slide to memory, Judge. I'm depending on my opening statement to present to the court, to the jury judge. So I'm asking the court to reconsider its position as it relates to Mr. Hughes. Respectfully.
All right. Ms. Steele?
I sent our entire PowerPoint to the state of Georgia last Tuesday.
Which the court has already. I do acknowledge that.
Now I did everything the court demanded.
All right.
So I'd like to use mine.
Okay. All right.
And Your Honor, to be clear, on behalf of Mr. Stillwell, I sent over all the.
When did you send it?
On Friday, I sent all the photos of the exhibits that I plan to use or the monsters I plan to use, save for one which I did not have physical custody of, which is a Fulton County jail uniform, which I.
It's never good when you hear excuses like this guy, but it gets crazy. So give me a moment here. Let's find the next spot. All right, so we're going to pick this up right where the state is finishing up their statements, and then we're going to hear the judge finish this off, and then we're going to talk about this.
Also request that the court allow the state to continue in the path that it has gone. We have complied with the court's directive.
No, you didn't actually. The court's directive was you were supposed to turn this over way beforehand, because then we could have corrected these issues and not spent 2 hours on doing this. I'm deeply disappointed in, because this is exactly what I told you all was going to happen, was that we are going to end up dealing with a lot of objections. And I mean, I don't mind dealing with the objections, but I got to have time to do so. So that's why I told you I had started having this discussion with you about a week, almost 2 weeks ago. Mr. Steele brought that up, saying, hey, go ahead and turn over your PowerPoints so that we can go ahead and, if the court mentioned, have as smooth as an opening statement as we possibly could. That obviously, very few people adhered to the court's instructions, and we find my words to you a self-fulfilling prophecy, meaning that we are still dealing with this particular issue, and our jurors are waiting on us. So,
all right, so we're back, guys. So that concluded some of the fun there. After that, the judge essentially backed off of excluding the PowerPoints. They took a break, and then the judge essentially said, okay, here's what we're going to do. We're going to go through it. I'm going to essentially hear every objection, and I'll sustain or I'll overrule, and we'll remove the individual slides, and then the final finished product will then be entered in, and then we're going to move on to opening statements. So ultimately, some of the PowerPoint presentation got in that the state wanted, some of it didn't, and then the state got the opportunity to deal with some objections they had over items that they didn't get to see. But overall, this was a blatant example of the state playing games, and it was willful. It was a willful attempt to try to subvert the process and hide things, or maybe it was just incompetence. Maybe it was just they're not ready. Maybe it's just the sheer volume of this case that, again, they're taking on, and then they're putting themselves in a position when the defense says, we want a speedy trial. And this is a situation that, probably is a case that should take years to get to trial. And they're having to do all of this work just in a vacuum. But of course, that's an advantage that the defense has, because when you make the case, and see, this is where Fannie Willis, I believe, has made mistakes in how she's approached these things. She's doing this for in my opinion, the lights, the camera, the exposure. She campaigned on these type of prosecutions, and she's like, I've got to jump in, and we've got to get this done, and we've got to get some high profile convictions. So we're not going to waste time on getting the indictments, even though, again, this is why if this was being done in a federal court, they would have everything wrapped up and ready to go, and they would be ready to rock and roll. They would have had a detailed grand jury. They'd have their witnesses lined up. They'd have their evidence lined up. And if it wasn't tied up in a tight little bow, they wouldn't be proceeding with prosecuting. But she felt like she had to because this is what she campaigned on, that she was going to do these things. And of course, the sheer volume of a prosecution like this, as she's learning, it overwhelms you. And then you get into a situation like this where you're missing deadlines, you're not following orders, and we'll see how this pans out. We'll see if she gets her conviction or not on these individuals. But it's definitely not looking good first day of opening statements to have them go as they did. Doesn't mean they won't get across the finish line here. They're going to be bringing in hundreds of witnesses to testify, and sometimes when you're bringing in that many witnesses and you're hearing about all these things, that jury's going to feel like, when you have this many people saying negative things about an individual or an organization, where there's smoke, there's fire, and that can, you know, play in the favor of the prosecution, even though everything should be viewed from the presumption of innocence. In other words, those 6 defendants are presumed innocent. YSL is presumed to be a record label and not a gang. But, you know, it doesn't always go that way. So, wild start to this trial. We are going to take a look in a separate video. I'm going to be going through, probably going to be playing it at 2 times speed to try to get through it. We're going to be listening to the opening statements of the prosecution, and then we're going to be listening to the opening statements of the defense, because this is going to be important. It's going to be important to try to understand what we're seeing throughout the trial. That's why, even if I don't get to watch all of the testimony, or I don't run back all the testimony, when we have an important case on this channel, we are going to watch the opening statements so we can understand the context of what we're seeing. Because a lot of times in trials, witnesses come in out of order. It's not a chronological story, and it's important that you get the roadmap. So you got to watch the roadmap. You got to watch the opening. You certainly got to watch the closing, and then you can kind of go through in between and kind of better understand what you're seeing and understand what's important. You know, there's times too where you see witnesses, they might put 5 or 6 witnesses on in succession, and all they're doing is laying a foundation. All they're doing is laying a chain of custody. And these are really not that important witnesses. They're coming on, they're testifying about a specific point. They don't even sometimes even get cross-examined, or maybe a small point's made in cross-examination and they move on. Big witnesses you want to look at are obviously, you know, anybody that's presenting, you know, physical evidence, like a criminologist or a DNA expert or crime scene processor. Lead detective is someone that's very important. And then witnesses to a crime. People that are going to be testifying about aspects of the crime, timeline witnesses. Those are the ones you want to come back to and go, okay, we want to watch them. Thing is, though, you've got to understand what portion they're testifying to. So the best way to do that is by following the opening statement. So we're going to come back. We're certainly going to do that. And we're going to get, I've got to finish watching them myself. As I mentioned, I've got about 2 hours left of the day to watch. Some of that is going to include the defenses of one of the defense attorneys' openings. So I'm looking forward to that. And then we're going to get into what I expect to be a long, drawn out trial. When you've got all these attorneys in the room, one witness will take hours, because you're going to have every one of those defendants is entitled to have that witness cross-examined. So when we get these very important witnesses on the stand, you're going to have 6 defense attorneys all trying to make their points. And hats off to this judge trying to keep everybody contained in a box and moving smoothly, because you're going to get a whole heck of a lot of of disruptions, objections, motions, and not to mention that if you look around that courtroom, you've got a lot of experienced defense attorneys in that room. And to be those prosecutors, having, you know, 6, 7, I mean, some of them have 2 or 3 attorneys around them. You've probably got 20 experienced defense attorneys in that room, all watching this trial. And normally you'd have 1 defense attorney and 1 prosecutor, and you'd have the 19 other defense attorneys wouldn't be able to do anything. these guys can all object. These guys can all interact. These guys are all going to be able to have their input made. Rest assured, it's going to be a wild, wild time and a fun trial to watch. So we will be absolutely watching it and tuning in. So look, right now we're kind of in that odd time where we're not going to see a lot of activity because the holidays are coming up. We may see a couple of trials come up, that are going to be outlier trials or things that they want to get done before the end of the year. Or in the situation of this trial, it's a multi-month trial. So they're beginning it just to keep it going and get it going and get this thing started. Probably be first part of January when we start to see a flow again and court starts to open up and we start to see that trial schedule get back on track. And Lord knows we're going to have a very, very active 2024. I'm looking forward to it. So in the meantime, guys, we're going to keep covering all the news. We're going to keep covering all the things that are going on. We're going to be doing some look backs. We're going to be watching some interrogations. We're going to be reacting to news, views. We're going to react to other people reacting to or reporting on things, other podcasts reporting on things. We are the watchers of justice. Remember, when justice works better when watched, so we will always be watching, and you should always be watching as well. And together, we're going to hopefully build this channel up to be able to be out there watching justice, reporting on things that need to be reported on, and bringing to light the justice process, warts and all, so that we can hopefully make the justice process smoother, better, fairer, and exactly how it's supposed to be, which, in my opinion, is a very patriotic thing to do because it's our justice system is what makes our country great. Anyways, guys, I hope you've enjoyed today's presentation. Like I said, I'll be back hopefully within the next couple of days. We're going to watch these opening statements together. I believe there's going to be more opening statements tomorrow. So once they're all finished, we'll try to get it all together in a nice presentation. We're going to probably have to put it on double time or time and a half to try to get through it all together. But we want to get through it together, break them down, understand, get that roadmap mapped out for this trial so we understand together what we're looking at and what we need to look at to help us be the 13th juror and analyze this case. So anyways, guys, in the meantime, let justice prevail.